through God, meaning that all of judge decision must be able to give a sense of divine justice for the people and the other one. This meaning is not only related to the search of justice, but also related to God, the justice which is based on God. Just in this case, justice does not only cover the responsibility of judge to the people, but also the responsibility of judge to the one and only God. To knowledge of divinity and exercising law is so important that legal decision made by law enforcers can create justice. One of God's demand in exercising fire criminal law is that legal decision must be made based on justice. The knowledge of divinity which conveys the sense of divine wisdom is an original law with natural values that innately exist. It does not need a juridical basis in criminal law system in Indonesia. Therefore, what has been found so far in the provisions of law in association with the knowledge of divinity is not a judicial foundations, juridical foundations, but is legal provision which emphasizes on the importance of the knowledge of divinity. Can you next slide? Yeah. We are going to talk about open criminal justice system in Indonesian context. All of the discussion aforementioned show that Indonesian criminal justice system with a Pancasila perspective is an open system. As an open system, criminal justice system does not work solitarily. It is also influenced by other elements. And open criminal justice system in its concretization or operation is influenced by institutions or the environment of society and the environment where people live. In conclusion, in the practice of criminal justice system, there will be factors which are fundamental, which cannot be controlled solely by a criminal justice system, because many factors influence it. Thus, the implementation of criminal justice system depend on attitude of behavior of other factors. This is accordance with Muladi's statement, stating that criminal justice system in its process will always experience interface, interaction, interconnection, and interdependence with its environment in society levels, covering from economic, political, education, and technological aspect, as well as a subsystem of criminal justice. Criminal justice system is highly influenced by external factors that make criminal justice system an open system. This means that it is a system which, in attempt to achieve its purpose, are highly influenced by environment and any aspect of society life. Laporta described the interface, especially interaction, interconnection, and interdependence of criminal justice system with its environment in ranks consisting of society of the first rank, economy, technology, education, and political, and the second rank, and substitutions or subsystem of criminal justice system as the third rank. Society is the first rank of the interface of criminal justice system with its environment. The importance of social behavior is in stigmatization. As for example, people assume that when a person is arrested and handcuffed means that he is a criminal, despite the presence of a presumption of innocence, which means that a person will not be charged guilty until final decision is issued. Despite any change of behavior shown by inmates during the sentence, they will come back to the society with bad guy label. This most of the time will under the reintegration process. In addition, in its operation, criminal justice system is also influenced by the perpetrators of an offense. When it's performing its function, criminal justice system can respect perpetrators' rights by not forcing confession. The success of the system will be greater. The consequence of power abuse committed in a criminal justice system to offenders might return to the system itself. Can next slide. Yeah. The conclusion of my talk this afternoon, criminal justice system with a Pancasila perspective means that in its practice, criminal justice system must prioritize human rights, the balance of the perpetrators and the victims' interests, divine justice, humanity, and substantive justice. As an open system, criminal justice system does not work in solitary. It must take into account the values of law and the sense of people justice, so that in practice, criminal justice system or criminal justice law is more contextual in exercising criminal law in order to gain success. Thank you.
Yeah, thank you very much, Mr. Kadarudin, for your good presentation about criminal law system in Indonesia. So before we are going to the next speaker, I would like to inform participants that Q&A session will be open up after the presentation of three speakers is done. So if you have a question, please write it down, a question in the chat. So now we are going to the next speaker. His name is Mr. Kaustup Anil Sakarwar, LLB, BTech. He is the Chief Justice of India in Judicial Law Clerk from 2019 until now. His educational background is a Bachelor of Laws from Symbiosis Law School in Pune and Bachelor of Technology from Gulf College of Engineering in Pune. He has several publications. The recent publication on April 2022, same as Mr. Kadarudin mentioned before, is about finishing point of the ICC and the International Criminal Law that presented at International E-Conference on the Convergence of International Law to National Law in the Era of Globalization by Fitzgerald. He has been awarded by Guinness World Record for maximum number of people solving the Rubik's Cube. It's so unique. Okay, I'm going to invite him. Hello, Mr. Kaustup Sakarwar.
Thank you. I'll just share my screen, just a second.
Okay. Mr. Sakarwar, you have 20 minutes for the presentation.
All right. First of all, thank you. Thank you very much for having me. Dr. Husni, Dr. Kadarudin especially. I can see Dr. Esti here, who had a quick word before, and everybody here who is present here. Thank you for having me. I am from India. I have done a bunch of degrees. I am pursuing my master's in law, and I have for the past more than a year have been the research assistant to the Chief Justice of India, and had a great opportunity to understand the criminal legal system in India a little better. Before I start with the presentation, a quick note is that I had only a couple of hours to make the presentation, which later on gave me some technical errors. So I have a bunch of it here and there. It's not the most refined presentation, but my idea of the presentation is to take you through what happens in the legal system. And I saw Dr. Kadarudin go into the origins of the criminal legal system in Indonesia. I though haven't included it, I'll add it while I'm speaking to you here. And yeah, I'll start with it. I hope you can see it. So the Indian legal system, and especially the criminal legal system in India, originates and does not come post-independence. The Indian Penal Code, which is a substantive code, the Criminal Procedure Codes, its origins, and the Indian Evidence Act, all of it comes as text that the British Raj gave sort of to India. The Criminal Procedure Code had its origins pre-independence, and then post-independence, we made a couple of changes and we have our own system. But it is based on the common law system. It is based on the way British established their criminal justice system. A codification of the same, maybe you could say a higher, a refined version of the same. And the Indian Penal Code since the 1860 has been substantively the same, barring few modifications here and there. What I'd like to go through is the criminal legal system. So it will be more towards the courts, towards this. And the substantive code here was called the Indian Penal Code. It was made by Lord Macaulay back in the day, and it has more or less remained the same. The problem with it being derived from a common law origin is it still holds a lot of features, the colonial features that it had. The objective was to provide the penal code for India, and it came in 1860. So that is 3 years after the first struggle for independence. In 1857, there was a Sepoy mutiny, and post which the British era, the British Raj thought that it would be wise to have a penal code in order to have a better colonial regime in India. Now, IPC is pretty basic. It lists all the crimes and all the punishments. It has a chapter based on general exceptions, as do most substantive laws. And it is the main skeleton of the criminal justice system. It has a lot of social moral provisions. It has 23 chapters and 511 sections defining offenses, everything else. It still has colonial traits like sedition, which is still part of it. I'll come to the end of the slide. I'll come to sedition and how it has changed in the last 2 months. So India has a large hierarchy of courts. It's a huge country with a massive population, and therefore there is a higher degree of hierarchy in India. The highest court of the land is Supreme Court, which is also the Constitution Court. We do not have a separation between benches. It's a highest court of appeal as well as the Constitution Court. So it has 33 judges, all deal simultaneously with as the highest court of appeal as well as the Constitution Court. A high court is a court for each state. In each state in India has a specialized high court, which is a court of appeal as well as a court of original jurisdiction and a writ jurisdiction. And when you come to the further geography, you have the metropolitan, which is in the metropolitan areas, and which are not metro areas have something called the district and sessions judge. Now, these metropolitan areas and these district and sessions courts are the trial courts. At High Court and definitely at the Supreme Court, there is no scope of trial happening. There is no evidence. There is no evidentiary statements taken. There is no evidence presented. High Court and Supreme Court are only appellate courts, especially in the criminal justice system. They are only appellate courts, and the entire trial is based only in the district and sessions court or the metropolitan courts. How are they divided amongst each other is on the basis of sentencing. So section 28, section 29, etc. come from the Code of Criminal Procedure, and what they decide is which court gets to deal with what crimes. And with respect to the gravity of offense, these three courts function. Say the judicial manager, first class, the sessions court, the district court, district and sessions court. So the highest, the most grave crimes are dealt with by the sessions and additional sessions judge, and once a sentence, India still has capital punishment. So once the sentence of death is given, it goes back to the High Court to confirm that sentence. Until the time the High Court doesn't confirm the sentence, there is no execution that happens. All crimes which